Welcome to One Happy Lawyer, the estate planning podcast.
Welcome to One Happy Lawyer, the estate planning podcast with Attorney Dan Krause, founder of Krause Estate Planning and Elder Law Center in Wisconsin. Dan has been practicing estate planning and elder law since 1999 and is a board-certified estate planner law specialist. I'm Lisa Mosby, and in this episode, we're focusing on what actually happened if someone dies without an estate plan in place here in Wisconsin. Dan will explain how the process works, who makes the decisions, and why the default rules don't always line up with what people expect or want for their families. Welcome, Dan.
Hey, thanks, Lisa. It's really great to meet you and to meet with you here today. And I'm looking forward to talking about the government's plan for you if something happens.
Dan, let's start with some basics today. When someone in Wisconsin passes away without an estate plan, what does that mean from a legal standpoint?
So if somebody passes away in Wisconsin without an estate plan, and this is the same in many other states, the state has a plan for them, and it's called intestate succession. And all that means is intestate means not testament, or no testament, no last will and testament, intestate. And then succession just means in what order people get stuff. So there's a law in Wisconsin. It's in the 850s in the Wisconsin statutes, and I don't remember the exact statute number, but it says if you die and you have no plan and there's no other plan that you've written out anywhere for who gets stuff, then it goes according to this law.
Is that the default inheritance law in Wisconsin there? How do those rules from that law decide who receives property when there's no will or trust?
So a lot of people think that if you have no plan or if you don't have a will or a trust or something like that, then your assets go to the state. That is not true. But it may not go where you want it to go. Now, in very limited circumstances, the state actually does get your stuff. But if you have no spouse and no children, the intestate statute says that it goes to your parents. All of your stuff just goes to your parents. If your parents are not living, then it goes down the line of succession from your parents. So first line after your parents would be siblings. And if you have no siblings, or if your siblings have passed away, it might go to your nieces and nephews, and it goes down that line until it finds somebody. Now, if you're married and have no children or no descendants, then your spouse would get everything. And if your spouse wasn't there, of course, then you wouldn't have been married, so we don't have to go through that. If you're unmarried, but you have descendants, so you may have small children, you may have grown children, you may have just grandchildren because your actual children have passed away. In any case, your descendants get whatever it would have been. And now the way that they go with the descendants, it's called per stirpes, and that's Latin, and it just means that if a parent of the child has passed away, then the child gets whatever the parent would have gotten, or the children. So if there are two children, then they would share equally in whatever the parent would have gotten. So if you have, God forbid, two children, one of them has passed away, and then you die intestate, then one of your children would get their half, and your grandchild or grandchildren from the other child would get the other half. Now, it gets much more complicated if you have children and you're married, but your children are not the children of your spouse, or maybe at least one of your children is not your spouse's child. And this is fairly common. It's a mixed family. It's second, third marriages, however that goes. And what would happen in Wisconsin if you did not have a plan and there was no other way for your assets to be managed, then the law says that it goes half to your children, half to your spouse. And this causes all kinds of havoc, as you can imagine.
Sounds like we need to make sure we have a plan. We don't often think about it, but more and more people are becoming aware of the needs for this.
Absolutely, Lisa. Um, people say when I explain to this, well, half goes to the spouse and half goes to the children. And most people say that sounds like just a disaster. And it normally is. And they say, well, why would they make such a rule? Well, they had to choose something. So they split the baby, which is always a bad idea. But it's easy to get out of it, just like you suggested. All you have to do is create your own estate plan. And once you've created your own estate plan by a legal will or trust or other means, then boom, you don't have to deal with those rules about who gets your stuff. You get to choose.
Now that we've covered the assets, in situations like this, who ends up making decisions about things like finances, property, or personal belongings if the person didn't name anyone ahead of time?
So, in the case of a person, let's say, becoming incapacitated, maybe they have a stroke, or maybe their mental capacity has gone downhill from Alzheimer's or some other need during their or some other cause during their incapacity. The state has a plan for who's going to take over for them. Now, it's not easy to determine who that's going to be until you've gone to court and the court hears evidence, and then the court can choose somebody to be your guardian. So, anybody that does not have a plan and needs somebody to make decisions for them, financial decisions, healthcare decisions, decisions about where they're going to live, any kind of decision about their life, really, need those decisions need to be given over to a guardian. So that's what happens, and the only way to get a guardian in Wisconsin is to go through a court process. They want to make sure that they're not taking away people's rights who actually have capacity. So there has to be a court, a judge hearing testimony from a doctor, and then they'll hear testimony if different people want to be the guardian to see who's the best fit. And sometimes there's nobody that wants to step forward, or there's nobody who is qualified, or maybe nobody who really is close enough in the family. And then they'll choose a corporate guardian oftentimes, or a person who makes money by doing guardianship services. It's a much needed service, but most people would not want to have somebody that they've never met, somebody outside of their family, really being their guardian. So, in order to avoid that, people should do powers of attorney, healthcare powers, and financial powers. And they should make sure that those documents are set up like they want. And also, we really like the financial powers of attorney to be very specific and very broad, because we never know what's going to need to come up in those situations.
So we've covered the assets, we've covered the person who's going to be making the decisions. How does the probate process typically unfold in Wisconsin when there's no estate plan? And what does that look like for the families left behind?
So the probate process is just a process that needs to be done if somebody doesn't have a plan, if they're intestate, or even, and people don't realize this, if you have a will, you still have to go through the probate process in order for the will to take effect. Let me just explain that first. If you do have a will and it's perfectly laid out and it's properly witnessed and notarized and it's a perfectly good will, it's all legal and everything. If you just take that will after somebody dies, if you take their will into the bank is not going to give you control of their stuff. The bank is going to say, you need to take that will into the court so that the court can approve it. And then you bring back the letter from the court that says you've been given the powers by the court in order to administer this will or this probate case. So the person would take the will into the court, or send it into the court, or hire an attorney to bring it into the court, and then ask for the court to approve the will, and then allow the personal representative or the executor named in the will to start taking over and doing an inventory and paying off the bills and making sure everything happens like it's supposed to. Now, the process is the same if you don't have a plan at all. You have to go into the court and you just say that the person was intestate, so that they had no will. And then instead of taking the person's name who's listed in the will to be the personal representative, somebody has to come forward and say, I volunteer to be personal representative. In that case, it's usually some member of the family or member of the extended family, but it can also be somebody that you owed money to. So if they want to make sure that they can get access to your bank accounts in order to pay the debt that they have to you, they can start a probate and see whether they can get somebody to be the personal representative. Sometimes it's a bank trust department. Sometimes it's an attorney that the court picks or knows. But oftentimes, and most of the time, it's somebody in the family or extended family who ends up raising their hand, going into court saying, I'm willing to do this. Unfortunately, sometimes it's people who have maybe ulterior motives as to why they want to get close to your money and manage the estate. But most times it's somebody who has the best interest in mind, just wants to close things up. So you have to go into court, you have to open the case, you have to put a notice in the paper that says if you think that this person owed you money, then you need to make a claim by such and such a date. Also, you have to search down the heirs. So when we talked about the intestate succession rules, you have to look at those rules and see who would inherit or who's going to inherit according to intestate succession. And then you have to notify all of those people of the fact that this is going on. Now, this is sometimes an issue for people. Let's just say you have 3 kids. One of your kids was born first, and you didn't really have a relationship with them. It was a bad thing, and it was 50 years ago, and things fell apart, and you never really had any relationship with them. You didn't have access to them. And we see these sad cases. Generally, let's say this person did a will, and they wanted only 2 of their kids to get anything. Sure, that's fine. So you do that, you're allowed to disinherit anybody, any of your kids that are over the age of 18. There's restrictions for people that you have a responsibility of supporting. But as long as the kid's over the age of 18, you could give everything to charity or your neighbor if you wanted to. So if you want to disinherit the one child and the other 2 children are the only ones getting it, still is necessary, if it's a probate case, to notify that 3rd child, give them a copy of the will, and ask them, do you want to object? And all they have to do is say, oh, great, thanks for letting me know that this person I haven't talked to in 50 years has died and that I might be able to get something from this estate. Yes, I want to object because I'm not named in the will. So the probate court invites conflict, unfortunately, because of the fact that you have to notify anybody who's left out, even though that's not what you had wanted. So that's kind of how probate gets started. Probate is a complicated court procedure, and there's a lot of forms and rules and time limits, etc., that go along with it. Most people consider it to be bothersome and a pain in the butt, and it's often expensive. So, Lisa, that's kind of how probate goes. So if you don't have a plan, meaning that there's no written, legally enforceable written rules for what's going to happen to your stuff, or if your plan involves a will instead of a trust, then it's likely that there's going to be a probate of your estate after you've passed away, which means that they'll have to go through these procedures. It's getting worse and worse as far as the probate court goes. Now, the probate court commissioners and the registrars of probate around the state all have different ways that they like things done, and that's just fine. Their job is hard, and they need to make sure that all these cases move through the system. So what happens when a person goes through probate is all of these documents, including the document called an inventory, which lists all the assets that you owned at your death, and a document called the accounting, which is done at the end that says, this is where all the assets went. Are the expenses of the estate. This is the administrative expenses. These are income things that came in maybe from a rental property during the probate. And then in the end, this is where everything goes. And it's public knowledge. It's public access. And Wisconsin has electronic access to court records. So anybody, whether they're in North Korea or Russia or the EU or next door neighbor, they can snoop and see who's going to get money, and they can see their name and their address right online, and they can see approximately how much they're going to get when they look and see what the probate fee is, because it's based on the amount that's in the inventory. And if they want to, they can travel to the county courthouse and they can just open up the entire file and look at all the details. But just from online, you can tell how big is the probate, who are the interested parties that are going to get money, how much are they going to get, and then it opens them up to scams and fraud and things like that.
Dan, let's leave our audience with one final thought here. When families are trying to make sense out of all of this after a loss, what do you wish more people understood about the role of an estate plan and making sure they have one before they need it?
Well, I just wish I could show people, Lisa, the relief on children's faces when they find out that everything is set up. If you can imagine even something it's not easy and it doesn't take no time at all, but it's much shorter than a probate. Imagine that somebody that you love has died. Now it's up to you to plan a funeral. It's hard to do. It's over in a few days or a week, or it can be, but it's a lot of stress. Now imagine something like that happening, and then the procedure and the process takes over a year. Wouldn't you be much happier if somebody had set things up so you didn't have to make the decisions? You just had to follow the directions, and it just helps. It helps people to get past just the financial things, the legal things, instead of making it drag out and just, I guess, souring a little bit the sweetness of the memory of the person.
Well said. And that's it for today's episode of One Happy Lawyer, the Estate Planning Podcast. If you'd like to learn more about Attorney Dan Krause and his work at Krause Estate Planning and Elder Law Center, you can visit estateplanningpeople.com. Thanks for listening. If this episode was helpful, be sure to leave a review, and share the episode with somebody who could use it. And come on back next week.
Thanks, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.